It's my honor to introduce Judge Waits today. Judge Waits has currently serves as Chief Administrative Law Judge over the Probate Hearings Division at the Department of Interior. He has served on the Regulations Initiative Working Group on probate-related regulations governing Indian trust probate proceedings. Judge Waits got an undergraduate degree from the University of Wyoming, and he got his law degree at Boat Hall at University of California at Berkeley. And then after law school, Judge Waits worked for California Indian Legal Services and the American Indian Lawyer Training Program before he went into private practice in New Mexico. He also taught federal Indian law at the University of New Mexico. And Judge Waits is an enrolled member of the Eastern Shoshone Tribe at Wind River, Wyoming. So we'll go ahead and turn it over to you, Judge Waits.
Okay. Can you hear me? I guess this thing is working. All right. I guess this is the clicker. So. All right. How many lawyers we have here? Lots of lawyers. Okay. Law students? Any law students? One in the back, okay. Paralegals? Okay. All of you involved in some form of estate planning, will drafting, that sort of thing at one time or another, I suppose? Otherwise you wouldn't be here, right? Trying to figure this out. Okay, let's see here. Today we're going to talk about Indian probate a little bit. As if you haven't already heard a lot about Indian probate, you're going to hear some more from me. We're going to talk about APRA in a little more detail than you got already, although you've gotten quite a bit about APRA already. So maybe I'll probably go over a lot of the same stuff you've heard. Repetition reinforces learning, they say. And so we're going to repeat a few things. We'll also talk about Indian wills, because that's where most of you lawyers are going to come into play, and the paralegals who are drafting these things, and that's presumably what we want to try to get towards. We'll talk about some alternatives to wills, but mostly that's what we're going to talk about, is the wills part of it. So, first of all, thank you all for inviting me here again. I guess I must not have offended people too badly, because I keep getting invited back. So we'll keep going as long as we can. Now then, just a summary of the Indian probate process. It all starts when somebody dies. Until somebody dies, we don't have a probate. And in this case, it's going to be somebody who has Indian trust property, either real property or they have some money in an IIM account. Otherwise, I'm not going to be involved. They may be involved in a tribal probate code or tribal probate proceeding somewhere. They may be involved in a state court probate proceeding somewhere. But I won't be involved, or none of the people from the Department of the Interior will be involved unless they have trust property, either money or real estate. When that happens, the BIA is the one who starts the process by developing the probate file. They gather up all the information, death certificates, birth certificates for all the children, other forms of relationship documents for the children, other heirs that there might be, and they put them all together in a file and they ship them over to us. We then adjudicate those probates. There are currently 12 judges including myself. And I do some probates, I do a lot of other administrative stuff, and I do this sort of thing. But we also have other judges around the country. We have an office in Minneapolis, in the Twin Cities areas. Actually, it's in Bloomington. We have an office in Rapid City. We have an office in Billings. We have an office in Sacramento. And our main office is in Albuquerque. We used to have some other offices. We've closed a few and consolidated some of our operations to streamline things a little bit. But that's where we start from with the adjudication process. Now, in that process, most of the time, we are going out to the reservations. We do hold some hearings in our local offices when it's convenient for people, but we try to go where people are to hold hearings so that they can get there. We also offer telephone. We've been looking into using Skype as a means of conducting hearings so people can actually see what's going on in the hearing and we can actually see the people that are remoting. Part of the problem is, since I've been doing this, I started doing this in 2005 and I've been doing it now for 13 years. One of the things that we've noticed in the old days, they used to go to the reservation and everybody would show up because everybody lived at the reservation. I've been to all 50 states. Not just doing these hearings, but I have been to many of those states since I started this job. I finished out the 50 states after I got this job. I've held hearings from Maine to California, from the Pacific Northwest to Florida, all across the country, because the Indians have become scattered. We're everywhere. We're invading. We've taken over the world, or we're working on it anyway. Maybe we're not there yet, but we're everywhere. So we go in many places, but we also do a lot of this teleconferencing because when we're now holding hearings, I've had hearings where I've had people calling in from Brazil. I've had people calling in from, I think Dubai was the farthest that I had somebody call from. And that gets a little tricky when you're trying to arrange a schedule when it's 17 or 18 hours difference in time zones from where you're holding the hearing, and how do you figure out where that goes? And somebody's going to be inconvenienced in that, but we try to give people the opportunity to participate whenever we can, even if it's by phone, if they have to call in. We haven't had one from space yet, but I guess there aren't too many Indian Alati astronauts. All right. Once we adjudicate the probate, we issue a decision, we send it back out, send it back to the BIA, and also to the Office of Special Trustee. If there was money involved, they have to distribute the money. What happened here? LTRO, that's part of the BIA. They distribute the land interests according to our decision. And then finally, the OST, they distribute the money, if there's any money to be distributed, to the heirs or to the devotees of the person who died. And that's the end. Yay, we're finished. With that case, we go on to the next one. At least we're finished until we get a reopening or a rehearing to add property or whatever, which happens from time to time. All right. We'll talk a little bit more in detail about our adjudication process because that's really the part that I'm involved in. The American Indian Probate Reform Act, APRA. We'll move on. There are some definitions you need to know. And it's not like we don't have enough definitions of Indian, but we've got another one. Indian, for the purpose of APRA, is pretty specific. It means someone who is an Indian, that is, they're a member of a tribe, or they're eligible to be a member of a tribe. We don't see too many of those. And we don't make a determination of whether somebody can be enrolled. That's up to the tribes. Although if we had a situation, we would have to make a call on whether we thought somebody was eligible. But in most cases, we're going to refer that back to the tribe to tell us, is this person eligible to be enrolled? Because that's one of the criteria, is either a member or eligible to be enrolled in a tribe. They have to be an owner. If they're an owner of trust property as of October 27, 2004, you remember that date you may have heard earlier? That's the date that APRA became law. Now, something else happened. It didn't really get implemented until later, but it became law. It was signed into law on October 27, 2004. So if someone was an owner of trust property, they had an ownership interest in trust property on that date, they are an Indian by this APRA definition for purposes of probate. That's all. There may not be an Indian for purposes of enrollment or for any other purpose, but for our purposes under APRA, they are an Indian if they meet those conditions. The other condition, another way to be an Indian for APRA purposes, is to be an IRA Indian. Not the Irish Republican Army, but the Indian Reorganization Act. And if you meet the definition that's in 25 U.S. Code 464, I believe it is, that defines an Indian for the IRA, it means 1/2 or more aggregate Indian blood. Now, you could have somebody who's 1/8 this, 1/8 that, 1/8 something else, 1/8 something else, and they're not qualified to be enrolled in any tribe, but as long as they get to the half of aggregate, they can qualify as an Indian under the IRA. We don't see very many of those. Usually people are going to be either the enrolled, or they're going to be eligible for enrollment, or they're going to be landowners. And then we have California. And California always says we're different. And sure enough, they are. Because in addition to all of those, you can actually be an Indian in California for purposes of inheriting land in California, regardless of when you owned your acquired your Indian interest, or interest in trust property. So even if it was after October 27, 2004, you acquired an interest in California for purposes of inheritance in California, you become an Indian no matter when you acquired that interest. Okay? So California had to be different. Actually, Congress had to make California different. That's what happened. Now, the other definition you need to know is who's an eligible heir. Because under APRA, they narrowed who can inherit, and they narrowed how they can inherit. Now, one of the criteria is you have to be an eligible heir, or you can be a devotee. We'll talk about that when we get to the wills. But to be an eligible heir, you have to be a child, a grandchild, a great-grandchild, a sibling, or a parent. And in addition, you have to be Indian. Back to the first definition. Or you have to be a lineal descendant of an Indian within 2 degrees of consanguinity of any Indian. And we'll talk about what that means in just a minute, so hold on to that thought. Or you have to be a co-owner in the parcel where you would inherit. If you're a co-owner, regardless of whether you're any of those other things, you're an eligible heir. You could inherit more land in that same parcel. Even though you may not be an Indian, you could still inherit additional property in that parcel if you already own an interest. Okay? Now, I said we would talk about consanguinity. We will talk about consanguinity. What does that mean? Anybody? All of you lawyers? Law students? Law students should know consanguinity. Consanguinity simply means related by blood. It's a blood relationship. If you're related by blood to any Indian within 2 degrees, then you can be an eligible heir. Remember, we talked about 2 degrees of consanguinity, and we'll talk about what those degrees are next. But it's a blood relationship. You have to have some blood relationship to another Indian. Doesn't have to be the decedent in this case. It can be somebody else. You just have to be related to an Indian. Now, this chart here will talk about the degrees. If you can see it, what you see, this thing doesn't have a pointer, I don't think. Maybe it does. I guess not. Oh well. What you can see is all of these lines, like here and here and here, and even these dotted lines out here. Each line represents a degree. Each connection is a degree. So from parent to the Indian to their parent is 1 degree. Indian to their child is 1 degree. Indian to their grandchild is 2 degrees. 1 here, 1 here. To a great-grandchild is 3 degrees. This one, and this one. Same way going up. Each link adds on to the number of degrees. So if you're getting out here to cousins, you're going up to the parent, up to the grandparent, out here to an uncle, down to the cousin, so on. You're out to 4 degrees. Remember, we only talked about eligibility being 2 degrees. So who does not inherit? That's the real question. It's almost easier to talk about when we get to intestacy, which is governed by 2206A, 25 USC 2206A, part of APRA. Intestacy, no will, of course. Who does not inherit? We start with that same chart, and these are the first ones to go, the grandparents. There is no provision in APRA for grandparents to inherit. It will go up to parents, but not to grandparents. Unlike what we used to do, we would go chasing all over the pedigree to find heirs. We don't do that anymore. Next to not inherit is uncles and cousins, aunts and cousins out there. More than 3 degrees, and they're not even included in APRA anyway. So it doesn't matter. They could be Indian, we don't care. At least Congress didn't care. They said, we're cutting it off. We're not going to allow those people to inherit out here. What else? Nephews, nieces, grandnieces, any of those people, they're not included either. They are not heirs under APRA. So what we're left with is this sort of little person-looking thing here in the middle. The sisters, parents, brothers, children, grandchildren, great-grandchildren. The order is a little different. From the Indian decedent now, child, grandchildren, great-grandchildren, then parents, then siblings. That's the order of living people who can inherit. After that, we get to the tribes. Tribes, as somebody, I think Deb mentioned earlier, tribes are an heir under APRA. We used to talk about escheat. We don't talk about escheat anymore. The tribe is an heir under APRA. They are listed next after all of these have been exhausted. If you have none of these, and we'll talk, there's a few more restrictions on these as we go along that apply when you're talking about these things. First restriction is that children and grandchildren inherit by representation. What does that mean? Lawyers? It means that if a child has died, their children step into their shoes and they take by representation. Now, we don't use the newfangled stuff about what's it called, per capita at each generation. We don't do that. We use the old per stirpes representation. So each child, however many kids they had, their share goes to their kids. We don't aggregate them and divide it among all of them, like some state laws have done. That's the per capita at each generation. We look at each individual. If they have died before the decedent that we're dealing with, then their grandchildren or their children will step up and take their share at this level, at the grandchild level. After that, we don't do that anymore. We only divide it among surviving people. So at the great-grandchild level, sisters, parents, brothers, they have to have survived the decedent in order to inherit. If they did not live beyond the date of the decedent's death, they are not going to inherit, nor will any of their progeny inherit through them. Only grandchildren can inherit by representation under APRA. After that, it's all survivors. Okay? Any questions? If you have questions, raise your hand. We'll try to answer them as I go along, because I think we got enough time to do that. And if I put you to sleep, just don't let your head bounce off the table. Okay? All right, let's move on. Now, who does inherit? Well, that's going to depend. It will depend on what kind of an asset we have, because there are three kinds we'll talk about. The three categories of assets that we're going to look at are pretty simple. Cash in an IIM account. That's the easy one. Well, it's not the easy one because Congress didn't quite finish that one. Congress said, well, we're gonna divide up cash in the IIM account this way. If the person was married, their surviving spouse will get 1/3. And we're not going to talk about eligible or not eligible. If they have a surviving spouse, their surviving spouse is going to get 1/3 of the cash, period. Whatever's there. It may be 3 cents. It may be $3 million. We've seen all of them in between. Now, how does that work? Well, first of all, we have to determine what's the balance on the date of death, because one of the things that happens is when we look at the balance on date of death, we're talking about money that is in the IIM account on the date of death and money that was due on or before the date of death but may have been paid afterwards. If it was due on the date of death, we consider it part of the date of death balance, even though it might not have been paid yet. And we see a fair amount of that. Lease income. Lease is due January 1st. It gets paid April 1st. Person died February 15th. The money that got paid in April is actually part of the date of death balance because it was due in January before the person died. So that's something OST has to figure out after we make a decision. But we look at that, and that money gets divided up with 1/3 going to a surviving spouse if there was one, and if there was one, the other 2/3 get divided among the heirs that we just talked about, in that order. Children, grandchildren, great-grandchildren, parents, siblings. With survival being required at most of the stages after grandchildren. If there was no surviving spouse, of course, all of the money gets divided up among the other heirs. So the surviving spouse will take 1/3 of cash if there was one, and everything else gets divided among the other heirs. Pretty simple for money. Except, what happens if there are none of those heirs? If you've gone through all of the living heirs, you've hit the end of the siblings, and there is none of the above. No children, no grandchildren, no great-grandchildren, no surviving parents, no surviving siblings. What happens? That's where Congress dropped the ball. They didn't provide for that. They just got as far as the end of the siblings, and then they didn't put anything else in there. Now, the Board of Indian Appeals has had that case come up. It's called the Warrenan case, Robert Warrenan. And what they said is, look, it's going to go to the tribe with jurisdiction, just like land would. Well, that was pretty simple in that case because there was only one tribe. It was White Earth. And there was only land at one tribe at White Earth. So it was real simple. Goes to White Earth. Not a problem. Until you get out here. You get out here in the west, and what you see is people who have land at Wind River, and they have land at Northern Cheyenne, and they have land at Concho. So now who's the tribe with jurisdiction? Warrenan didn't answer that question. And we haven't had a board case yet to answer that question that I'm aware of, unless it came out in the last week or two. There is no answer. We're in the process of working on regulations to try to fill in the blanks. And one of the proposals is, look, if there's more than one tribe with land, we're just going to divide the money equally. Another thought is we track the money back to where it came from. So if it came from a lease at Northern Cheyenne, then it would go to the Northern Cheyenne. If it came from a lease at Concho, it would go to Concho, to those tribes. The problem is that IIM accounts can have other money that we can't trace to any land. They can have Social Security payments. They can go into an IIM account. VA benefits can go into an IIM account. There may be some others that I'm not quite aware of that could be in that money. And you can't trace it back to any tribal land anywhere because it came from something else. So we're trying to fill in the blanks with something that's reasonable and fair, and those are kind of the two things we came up with. If anybody has any other ideas, you're welcome to let us know. And we'll throw those into the mix as well, because we're trying to revise the regulations to provide some guidance to the judges so that they can, as we're dealing with these things, we're sort of, everybody has their own point of view at this point, and until the Board of Indian Appeals tells us otherwise, I may decide it one way, and Judge Yellowtail may decide it a different way, and Judge Pfister may decide it yet a third way, depending on point of view. And that gets reconciled when the Board of Indian Appeals says, okay, you're right or you're wrong, or whoever's right, somebody else is wrong, whatever. And then we get a rule like Warrenan, which they did. But we haven't got that yet. So we're still in that flux period of trying to sort it out. But we think that if we can do it by regulation, at least we provide some guidance. The board usually follows the regulations and say, well, if the regulations are okay, we'll go with it. Now, there is a question of what's the authority to do that, because APRA doesn't really say, and we don't really have any statutory authority beyond children, grandchildren, etc. But we're filling in the blanks, and we're using Warrenan as an example for how to do that. And we'll see. So far, nobody's taken it to the district court, U.S. District Court, so we don't have any answer from outside of our administrative process. All right, any questions about money? Piece of cake, everybody understands it, right?
Where does the definition of spouse lie?
Up what?
The definition of spouse.
Definition of spouse is someone who's married to the decedent by, and that's where it gets tricky. It can be an Indian custom marriage, if there is such a thing. It can be a common law marriage, which you have here in Montana, but not on the Blackfeet Reservation, because Blackfeet doesn't recognize common law marriages. So if you have Blackfeet living in Billings, they can get married by common law, but if you have Blackfeet living in Browning, Okay, common law marriage, those are the hard ones because they're so factually based. The general rule is people have to have agreed to be married, and they have to live together or held themselves out as married to the general public with the intention of being married. And there's no time limit on that. There's a lot of myths. Live together for one night and you're married. No. Live together for 6 years and you're married. Maybe. Who knows? I had a case one time, and I think it was, I forget where it was. I think it was in Idaho, before they abolished common laws in Idaho, which I think was in 1996. And so I was asking the person who was saying, well, we were married by common law. And I'm looking at the record, and the record said, well, they were married by common law, then they got a divorce. Okay? And she says, well, but we got married again afterwards. We got back together, and so we were married. And so I asked my usual questions, okay? Did he agree to be married to you? Oh, no, he didn't want to get married. He never wanted to be married. after we got divorced. So that pretty much ends the discussion right there, because you have to have an agreement to be married. And if one party didn't agree to it, then you really don't have an agreement to be married, right? Isn't that what contracts are? You got to agree. Well, that kind of ended it, because she said he didn't want to be married. Now, if she'd said, yeah, we got back together, we wanted to be married and so on, then it'd be a little more difficult, because there really isn't much else evidence that you could bring in. But when she said, no, he didn't want to, that ended that case as far as the marriage was concerned. But that's the spouse under common law. Otherwise, it's a ceremonial marriage, license and all that sort of stuff. Now, some tribes have different rules. You can get married by tribal custom, but you have to register the marriage with the tribe in some cases. I think Fort Duchesne, Northern Ute is that way. They will allow you to be married by common law, but you have to register it before it'll be recognized. I'm not sure if that's Northern Ute or one of the other tribes in Colorado or Utah. But some tribes have their own rules. And some have a regular marriage statute. You comply with that, you go to the tribal judge, you get married, you get a license from the tribe. That's a marriage. That's a valid marriage as far as we're concerned. And most states will even recognize that as a marriage if you're dealing with those, as long as you've complied with the tribal rules and gotten married. So, does that answer your question?
Yes, sir.
That's a long answer to an easy question. But okay, any other questions? All right. Land. This is the second category. We talked about money. This is land where the interest that is owned is greater than or equal to 5% of the whole interest. We've heard a couple of people talk about these fractionated interests. In that document that was passed out, we had an interest that was what, 1.5%, 1.3%. That's a less than 5%. We'll talk about that in a minute. We get a few of them where they have 5% or more. Some places, we get a lot of them in Alaska, but then APRA doesn't apply in Alaska, so it doesn't matter. But we do get a lot of them in some of the places that were allotted later on. They haven't gotten to the point of fractionation yet as badly, although they're getting there. They're getting there very quickly. But if it's greater than 5%, then it pretty much goes the same way that we just talked about for money. Children, grandchildren by representation, great-grandchildren surviving, parents surviving, siblings surviving, and now they have to be eligible. Unlike for cash, where we're gonna, well, same thing is true with cash, except for surviving spouses. Surviving spouses with cash doesn't matter if they're Indian. Everyone else, they have to be an eligible heir, which means they have to meet that definition of eligible heir that we talked about earlier. Okay, so that's one difference when you get to those, that we have eligible heirs now for land and for cash other than for surviving spouses. Land greater than 5% is going to go, and it gets divided equally among all of those at each level. So equally among the children, with grandchildren who are the survivors of a predeceased child will take by representation again. Great-grandchildren, no, they have to survive to be a great-grandchild and take. Same thing with parents, same thing with siblings, and they have to be an eligible heir, as we talked about earlier. Indian, 2 degrees of consanguinity of an Indian, so on. Okay? Any questions? So far, everybody looks awake. All right, land less than 5%. Here we go back to jolly old England. We follow the rule, sort of primogeniture. It is the oldest surviving child, grandchild, great-grandchild. And that's where it stops. Then it goes to the tribe. We don't land where the ownership interest is less than 5%, like the one on this ITI you have that was passed out, only goes to children first, oldest surviving child. If there are none of them, oldest surviving grandchild. If there are none of them, oldest surviving great-grandchild. And if there are none of them, it goes to the tribe with jurisdiction. So it's a very narrow line when you have a less than 5% interest. And that was the source of a lot of trouble when we first started doing APRA cases back in about 2008, 2007. Took a while before we started seeing some of them. And people who weren't aware of this come in and you tell them, well, it's going to go to this oldest person or it's going to go to the tribe. And they go, wait a minute, what about the aunts and uncles and nieces and nephews and all of these other people? And we tell them, no, APRA doesn't allow for it outside of that direct line of descent by intestacy. And that made a few people unhappy. And now, you know, we've done enough and it's been around long enough, people are starting to become aware of that. We still surprise a few people with it because they haven't thought of it yet. Something that you can all do to educate people is let them know this as you go along. If you see them, when they come in, if they're coming in to talk about estate planning, you can talk about that with them. Because when it's going by intestacy, it gets very limited as to who can take. Now, any questions on that? We call that the single heir rule because only one person's going to take. And that's to avoid further fractionation of these interests. They're already small, less than 5% to begin with. And in order to stop them from getting smaller and smaller and smaller, it can only go to one person. All right. Now, I threw in the Northern Cheyenne Code here because they followed APRA. This isn't in the materials that you got, but I threw this in because generally Northern Cheyenne's probate code, which became effective for people who died on or after May 12, 2016, they followed APRA, except they said, if you're going to devise to a non-eligible devizee, when you make a will, all they can get is a life estate. And the remainder has to go to the first surviving eligible person in the order that we just talked about. So the first surviving eligible person gets it. If it's going devised to a non-Indian, that can be a spouse, it could be an adopted in non-Indian child or something like that. Any of those people who are not qualified as an Indian, under the Northern Cheyenne Code, they can only get a life estate. Okay. Ineligible devisees can renounce under the Northern Cheyenne Code to an eligible devizee. That's allowed. Okay. And also the last one there, a devise to a non-Indian may be purchased by the tribe at fair market value. With the devizee can retain a life estate if they so desire. That's really the major differences that Northern Cheyenne did from APRA. Otherwise, they pretty much adopted APRA. And that we've seen that in some of the other tribal codes that have been approved since APRA. Now,
So, wait, you said
let
the
me kind of
devisee
diverge
can-
here.
I'm
Yes.
sorry, you said the devisee could sell
What?
that, the devisee can sell to the tribe?
Yes.
Okay.
Or the tribe can buy it, basically, if they want to. If it's a non-eligible devizee, they're either going to get a life estate, okay, with the remainder going to an eligible heir, or they can sell it to the tribe and keep a life estate. They want to do that, if the tribe wants to buy it. Now, how active is Northern Cheyenne?
Very.
They're very active, okay. So likely that's probably what's going to happen, unless they renounce to an eligible heir, which keeps it in the line.
How is fair market value determined?
By appraisal.
By whom?
By,
ABSO.
Office of Valuation Services, Office of Appraisal Service, what are they called now?
AVSO, Appraisal Valuation Services Office.
Okay, AVSO, Appraisal Valuation Services Office. And they're part of PMB?
Yep.
Okay. All of these agencies got shuffled around, and it's hard to keep up with where they belong these days, because they used to be part of OST, right? At one time, Office of Appraisal Services was part of OST. Now they've been moved. Okay. But they have appraisers that do these things. And that's been an issue of how do you appraise a fractional interest? You know, so as I think you may have mentioned it earlier, who's going to buy a 1/54th interest? Well, the tribe will, in many cases. But how do you value that? Because as we all know, what's the value of a 1/54th interest? Is it 1/54th of the whole value? Probably not, because there's not much of a market for it. But we've adopted the convention that we figure out the full value of this property as if it were a whole, and then we apply the fraction. And that's the purchase price that we use. Okay? It may not be rational, but we figure it's fair. All right. Any other questions about Northern Cheyenne? Now, there are some other codes, and there are some in the works. I'm not sure how many, but there are several that I'm aware of. In this area, I don't know how many there are other than Northern Cheyenne, which have any other tribes?
I think CSKT was working on a code, weren't they, Francis?
Who is?
Flathead?
Yeah, they're trying to. This is the greatest.
I know Oglala's was working on one. They had submitted it, and I think it came back. Fond du Lac has one. Theirs has been approved. We also have some. Now, APRA is not the only thing that's going to apply out here, but you probably are not going to see too many of them because we have some federal probate codes, Standing Rock,
Warm Springs.
Sisseton. What's the other one? Can't think of the other one. Then there are some inheritance codes in the Pacific Northwest. There's Warm Springs, Nez Perce, and Yuma. I can't think of the other one right now. Yakima, right, Yakima. Those are the federal ones. And then there's some tribal codes like Umatilla, Salt River, Northern Cheyenne. These have all been approved. So, you know, we started out, when I started doing this, we applied the law of about 25 states or so, because where the land was located, we used the law of that state. And actually, it sometimes was 50 states, because where the cash was, we used the law of that state, where the person resided, as the law of descent. And then APRA came along and changed that, except for the ones that already had a statutory code. And now we're seeing tribes adopting new codes. So we've gone from big, wide array of probate codes to apply, down to APRA and Alaska, because they got accepted from APRA. And now we're growing back with tribal probate codes. And how many tribes are there? 567. Probably not going to get 567 probate codes, because there isn't trust land in 567 tribes. A lot of the tribes don't have any trust land. So they may have their own tribal probate code, but we're not going to be using it because we only deal with the trust land. So if their probate code applies to trust land, we'll deal with it. If not, we don't. All right. Moving right along. Indian wills. This is where you all come in. Now, there's a couple of things that I want to talk about Indian wills that are you probably need to be aware of. First thing I will say is that when you're drafting a will for an Indian person with trust property, I'm going to suggest that you put a separate clause in the will just dealing with the trust property. Okay? Because if you do that, then you can single out how that's going to happen and deal with it, and then it's clean. And when we look at the will, We can concentrate on that particular piece, and we don't have to worry about all of the things like what happens to the Maserati. Okay? Or what happens to the drums, or whatever else there might be that's non-trust property. We don't have to get into that. We see a lot of wills, too many wills at least, where the will says, I give everything I own to my family trust. That's a no-no. Do not do that. Whatever you do, do not do that yet. Deb talked about the pilot project for family trust, and she also said there are no regulations. That is not in effect yet. It's in the statute to allow for it, but it says we're going to have a pilot project and we're going to figure out how to do it. We haven't yet, so it hasn't there. But if you give it to if you put trust land in a private trust, that's malpractice. Okay, in my opinion. Because what's going to happen to it, now it may turn out to be okay. What's going to happen is that when it goes into the private trust, it goes out of federal trust. It becomes fee land, in essence. Because we do not hold land, or the department does not hold land in trust for a non-Indian entity. And a private trust is a non-Indian entity, even if the trustee is an Indian. Because the trust is a separate entity from the person. The person is just the acting person in place of the trust. So if you're doing a will for someone in part of their estate plan, it's a good idea to put their property into a private trust so they can pass it on without having to go through the probate process. It's especially important to carve out the Indian property and keep that separate and not put it into that private trust. As we've said, we might work on that at some point and that could be allowed, and it would help because right now our average processing time in OHA is about 8 months from the time we get a case in until we get it out. That's average. We have some that are a lot older than that because of complications. We have some that we get out the door pretty quickly because of scheduling. But the average time it takes in OHA is about 8 months from door in to door out. That doesn't count the time that BIA has taken in case prep. And we've had some of them that take 2 or 3 years or 4 years or 5 years. And we've had some that take a couple of months. It just varies on caseload and personnel and who's there and what information is available and how much work they have to do before it gets out the door. My uncle's case, I think he died in 2011. We finally had a probate in 2014. And it was not complicated. He had a will, but we had problems figuring out who was everybody that belonged there. Now, not that there were a lot of us. There were only 2 of us, me and my sister. But there was some issues with the money, and the bulk of it was workload at the agency. They just had so many cases, it took them that long to get to it. Yes?
I'm confused. Earlier, we were told that you cannot put trust property into a trust. And I thought I just heard you say that you could do that, but it changes the trust property to fee property.
Yes, you can do that in some cases. For example, you can do it at Wind River because they're non-IRA. So you can give land to a non-Indian at Wind River by will. Who was it was talking? Crow, right? Was it Crow, Northern Cheyenne? Who's IRA up here? Huh?
Both are IRA.
Both are IRA. If it's an IRA tribe, the IRA prevents that. You can't give it to a non-Indian on an IRA reservation. So if that's the case, then you can't do it anyway. But there are a lot of tribes that didn't adopt the IRA. And if you give it to that trust on a non-IRA reservation, it's going to pass out of trust. It'll go to that tribe or to that trust. And then it gets removed from federal trust protection once it goes to that trust, private trust. So yes, you can, or no, you can't, but it depends on the individual circumstances. If it's an IRA reservation, no, you can't, because you can't give it to a non-Indian on an IRA reservation. Just like at Northern Cheyenne, under their code, you can't give it to a non-eligible person. All they'll get is a life estate. Okay? So it's important to keep that distinction in mind. That's why I suggest that when you do these things, if you have Indian trust property involved, carve that out and put it in a separate paragraph or clause in the will and deal with it separately. That way you don't run the risk of inadvertently lumping it all into one and having it pass out of trust because somebody forgot. Now I had one down, where was it? I think it was at Southern Ute or somewhere down in Utah, where I told them that it was going to pass out of trust because it all went into a trust. And they said, oh, we can't have that. So I said, okay, well, you can figure out how you want to deal with this by a settlement agreement or whatever you want to do. And they said, we want to do that. So I sent them away and said, go figure this out. And then they came back later and said, no, we want it to go out of trust. So we want it in fee. They changed their mind, I guess, and decided that they wanted it to go ahead and go in fee, except not all of them did. But they couldn't come up with an agreement, so it ended up going to the trust, because that's what the will provided. And it went out of trust status, federal trust. Best to keep it all separate and deal with each one separate. And you can deal with all the other stuff, put it all in the trust, do whatever they want to do with it. But keep the Indian trust property separate, and the reason for that is if they want to maintain federal trust protection, it has to stay in Indian ownership. Or at least it has to be devised to an individual. Now we'll talk about that for just a minute, because there are other ways to deal with things besides wills. As I said, it takes 8 months for us. It takes at least 6 months usually for the BIA to get it to us. In an ideal circumstance, it's probably going to be at least a year from when they died until we get a decision out the door, if not longer. So what other ways can you do? Well, the other way is a gift deed. And that comes with its own caveat. Because if they gift deed it, they can't get it back if they change their mind. Once it's gone, they can gift deed it, retain a life estate if they want to keep the income while they're alive, but once they sign that gift deed and it gets approved, it's gone. They can't get it back. And if that person predeceases, it's going to go to their heirs. It doesn't come back to the person who gave it to them. It goes to their heirs. So that's the caveat with gift deeds. It's one way to avoid this problem of how long it takes to get land from one place to another, from one person to another, is to avoid it by gift deed, because then we don't pay any attention to it. It doesn't even show up on their inventory. It's never part of their probate. It's gone. It's already owned by that other person. But they can't get it back if they change their mind. Yes?
And are gift deeds governed by different tribal codes as well, like if they can do them or not, or?
No, gift deeds are basically governed by federal law, and they have to be approved by the Bureau of Indian Affairs. And again, the situation, you can apply to have it taken out of trust if you really want it to pass out of trust. And we've had some people do. They don't want it to be controlled by the feds. They want their own land, and they want to be able to control it. And if they can do that, they can certainly take it out of trust. But although under APRA, if you want to take it out of trust, the tribe has the right to buy it. So if you decide, hey, I want to take my land out of trust, you have to notify the tribe, and they have the right to step in and say, we're going to buy it. Because you can't just take it out of trust. Okay?
So when would gift deeds be approved? I mean, if the tribe doesn't want the land?
Yeah, basically. Well, if it's going out of trust. Now, if it's staying in trust, if you're going to give it to your eligible child who's also enrolled, then the tribe probably isn't going to care. unless they want the land for some other purpose. They're not gonna care if you wanna give it to your Indian child. The BIA is not gonna really look at that very closely. They're gonna say, well, is it a reasonable, likely thing that a person might do, and they'll probably approve it. Although that can take a while too. You know, sometimes it takes a while for that to get processed through the BIA and then get to LTRO and the title gets transferred and all that stuff. I've seen those take a while. In the course of doing probates, I've seen some where they applied for a gift deed, it got approved, and on the way to go sign the gift deed, they got in a car wreck and they died. Then what? No gift deed's been signed, it's been approved, and I think the Board of Indian Appeals said, in that case, OHA can decide that it could be approved anyway as a gift deed. But, you know, the downside of that is, how do we know that they weren't going down there to tear it up? They'd changed their mind. We don't know. And we're dependent on all the people who are living to tell us what they were going down there to do when they got in the car wreck and died. We don't really know. The presumption is they were going down to sign their gift deed so that it could be recorded and transfer the property, but we don't know that for sure. Do we? Okay. Any other questions? And I think, Deb, you mentioned, or somebody mentioned, thoughts of changing so that you can have a payable on death, both for the IIM account or for land. We don't have that yet, so we're still in the, either gonna do it by intestacy, or we're gonna do it by will, or we're gonna do it by gift deed, basically, at this point. That's where we are in the process. Okay. Who can make a will? If we're going to make a will, who can make one? And that's governed by regulation at 25 CFR 15.3. It's pretty simple. It's got to be 18 or over. Okay? You have to have testamentary capacity. That's where we get some of the fights. You have to own trust property. Don't get too many fights about that. Either they did or they didn't. The big fights that we get are testamentary capacity, undue influence. And it's kind of a toss-up between the two. Probably a few more on undue influence than we get on testamentary capacity, but we do get them both. You know, Mom didn't know what she was talking about when she made that will. She was totally around the bend. And more commonly we get, you know, in the last 6 months before she died, she was totally around the bend. Well, she made the will 5 years ago. It doesn't really matter that she was around the bend for the last 6 months of her life. We're looking at the time she made the will. Did she know what she was doing then? Did she have an idea? What are we looking at for testamentary capacity? We're looking to know, did this person understand what they owned in a general sense? We don't mean that they needed to know everything that they own, because I don't think anybody ever knows what they own in Indian country. At least judging by the number of reopenings to add property that we get. People, you can go down there and get your ITI, your inventory, whatever, on one day, and the next day it changes because somebody else added some property to it. But you have to know that. And you have to know the general objects of your bounty, as the term is. Who would you normally want to have your property? And, you know, we're looking at this after the fact. We can't sit there and ask the person who made the will, because they're not going to be in front of us anymore. So we're going to have to rely on what was going on in what we have. What did the witnesses have to say? Did they have anything to say when they signed the will? Did this person appear to know what they were doing, know what they were talking about, that sort of thing? That's what we're relying on in making this testamentary capacity determination. The other one is undue influence. That's a hard one, because the Board of Indian Appeals has dealt with that, and they've set forth some rules in some of the cases. person has to be subject to being influenced, number one. Were they subject to being influenced by somebody? And what does that mean? And does it mean, did somebody exercise enough control over their mind that they could make them do something? Think about that. How do you prove that? How do you prove that it wasn't? It's really hard to do. And secondly, after you prove that they could have been influenced, then you have to show that they actually were influenced. That's the second part of that. Were they really influenced, or was this still their own decision? And again, we can't ask them because they're gone. So we're relying on extrinsic evidence to talk about those things. So those are the hard ones. And it's a pretty high barrier that they've built on that, because we think, and the general rule is, if somebody takes the time to make a will, that's what they wanted to do with their property. That's what's in the will. We think that that's what they wanted. They went and had somebody draft this will. Well, not always. Story is of the will that was written on the wall in the fish camp in Alaska. They wrote it out on the wall. Okay? But generally, people have gone to an attorney, they've gone to an advocate of some sort to make a will. They've taken the steps to go do that. They've told them what they want. They go through it. So, you know, it's pretty good that we have that's there. Now, what are the requirements of a will? Those are pretty simple. First of all, they have to have been eligible to have a will, which we just talked about. Second of all, it has to be written on the wall of the fish camp. That works. It's in writing. We do not have oral wills. We do not have televised wills. We do not have tape-recorded wills. We do not have any of those things we don't recognize. Got to be in writing. Doesn't have to be typed. Doesn't have to be on paper. Can be anything that's written down somehow, or written on the wall somehow. So number one, it has to be in writing. Secondly, it has to be dated. When did they sign it? It has to be dated. This is in the requirements in 15.3 or 15.4. Yeah, 15.4. Has to be signed by the testator. Now, I've seen all kinds of things. X's, thumbprints. I didn't see Prince's will with the little squiggly whatever it is, but perhaps. Whatever they put on that piece of paper or on that writing that signifies their signature, we will accept it if it's proven to be their signature. If somebody comes in and said, yeah, they did it, they marked it with an X, the witnesses watched them mark it with an X and they signed it, or they watched them put their thumbprint on it, or they watched them draw their little picture on it, or whatever they did, if they intended that to be their signature, that's good enough. As long as it's witnessed, attested by two disinterested adult witnesses. And the Board of Indian Appeals has said that a notary can be one of those witnesses. So we often get the self-proved will. That is, you're all familiar with a self-proved will. There's an example of it in the regulations, I think at 15.7, the affidavit. The witnesses sign it, the testator sign it, the notary signs it. We've had situations, in fact, I was the evildoer that said this will is not valid because one of the witnesses that signed it is inheriting or taking under the will. So they're not a disinterested witness. And the Board of Indian Appeals said, not right. The notary signed it. And they were there and they're a witness. So you had the one that was disinterested and you had the notary who's a disinterested witness. The only thing you got to do now is you got to have it proved, because it's no longer a self-proved will because the notary can't be self-proving themselves. But you got to go back and do this. So we did. Got an affidavit from the notary that yes, I was there, watched them sign it and do all this sort of stuff. So now we have two disinterested adult witnesses. So you have to have that. Pretty much the same as most state law situations. Signed by the testator, dated by the testator, in writing, attested by 2 witnesses. 3 is okay, 4 is okay, but at least 2. Okay? Moving right along. We talked about self-proved wills. Well, 15.7 lays out the affidavit. If you want, just look in the regulations, it's right there. Most state court or state probate codes have similar things, and then usually if you comply with what's in the state, it will fit with ours. It just says that we were all there together, we signed it together in the presence of each other, we watched each other sign it, everybody signed it together. You repeat that 4 or 5 times and have it notarized. Okay, that'll do. It has to be done at the time the will is executed. Can't be done later. That doesn't make it a self-proved will if you come in with an affidavit later. Now it becomes a different kind of way of proving the will. All has to be done and has to be attached. 15.9 is the form. Sorry about that. Let's talk about what can be willed. Well, money, land. Where'd it go? Money, land. Those 2 things, that's what can be willed. Trust land, trust money in the IIM account. And if you happen to be in Alaska, trust reindeer. It's gonna be there. Trust reindeer as personal property in Alaska. But that's not under APRA. I thought that too. I had that same look when somebody said, trust reindeer. Yes, they have trust reindeer. Huh?
We thought you were pulling our legs.
I said, so that wasn't a joke?
Yeah, well, you know, you gotta go with what works where you are.
Yeah, I was waiting for you to come up with the punchline, I'm just joking.
No. And as far as I know, Santa Claus is not a native Alaskan.
Okay, all right, well, that's good to know too.
Yeah. The North Pole really is not part of Alaska, even though part of Alaska is above the Arctic Circle. All right. What can be willed? Well, you know, trust land, trust money, just what we've just been talking about. That's pretty much it. The real question is the next one. Does it stay in trust? Now, here's the difference between intestacy. Remember we talked about the 2 degrees of consanguinity and eligible heirs. Doesn't apply under a will. Under a will, as long as the land or money is passing to a lineal descendant of the testator. What's a lineal descendant? Children, grandchildren, great-grandchildren, great-great-grandchildren, so on down the line. As long as it's going down that line, it will stay in trust regardless of whether that person would otherwise be an eligible holder of a trust interest. And it will stay in trust. So that's the one situation where non-Indians, essentially who are non-Indians, like my great-grandchild, could have land in trust and have it stay in trust if they take by will, but that only lasts as long as it continues to pass by will. So it could continue indefinitely as long as at each passing it's passing by will to a lineal descendant. It can keep going. But once somebody forgets to make a will, what's going to happen? There aren't going to be any more eligible heirs, and it'll go to the tribe. So it's important that if it's passing by will, it can stay in trust, as long as it's going straight down line. Can't go up line, can't go out. Can't give it to your cousins, anything like that. Only down. Can't even give it to your spouse, who's a non-Indian. Only down. But as long as it goes only down at every generation or every passing by will, it will stay in trust.
And if you have no children, it goes to the tribe?
What?
If there's no children, then it would, or lineal
Well, yeah, I
descendants?
mean, well, if, we're talking about by will. If you try to give it to anybody other than a child, grandchild, great-grandchild, it's probably gonna end up going to the tribe. If you, I mean, you can give it to the tribe, of course, if you want to, and that's fine. So that's the other one. Lineal descendant, you can give it to a trust co-owner in the same parcel. So even if there are co-owners who are non-Indian, you can give it to them, and it will stay in trust, because they're already a trust co-owner. Okay. You can give it to the tribe that has jurisdiction over the parcel, and it stays in trust. Now, can you devise in fee? We'll talk about that in a minute. What about trust personally? Well, same thing generally, except that you can devise money to a non-Indian and it will pass out of trust, because they'll just write a check. Okay. That's the difference. It will stay in trust if it goes into their IAM account. If they're otherwise eligible, it will go to an eligible Indian devizee and stays in trust. It can even go in their IAM account and stay there, whatever. But you can pass personalty, cash, out of trust to pretty much anyone. We don't care about the IRA because the IRA doesn't apply to money, only applies to land. So if you give it by will to your church, what happens? If that's approved, they'll send a check to the church. Okay. If you give it to your best friend who's non-Indian, they'll send it to them. Doesn't matter, as long as it's cash. Okay. How about, I said we would talk about, no, that's trust personal, we already talked. Realty in fee, trust realty passing out of trust. Well, the general rule is you can do that if it's not an IRA tribe property. If it's an IRA, or like Northern Cheyenne under their tribal probate code, you can't do it. If it's an IRA tribe, you cannot pass trust property out of trust by will. Otherwise, you can. Non-IRA tribes, land on a non-IRA reservation, you can give it to anyone you want to out of trust, and it will pass to them out of trust, except if they're an Indian. There's a strange bit of language that says you cannot devise trust land to an Indian out of trust, which is a little weird because you can devise it to anyone else and it will pass out of trust, but you can't give it to an Indian out of trust. It's going to stay in trust if you give it to an Indian. Don't ask me what Congress was smoking that day, but that's what they did. Now, we'll talk a little bit about the IRA. That's 464. Any property subject to an IRA can be devised in trust only to an Indian or as a life estate with the remainder to an eligible Indian. Okay. So you can give them a life estate, but you can't give them the ownership interest, just the life estate interest. Cannot do it as a fee interest at all. A few more topics and we'll be done. Hey, I will be back on schedule in a minute. Joint tenancy. There is a presumption in APRA 2206C1 that says if you devise property to more than one person and you don't specify otherwise, it's presumed to pass in joint tenancy with right of survivorship. That's the presumption. And that's caused a few disagreements among the judicial corps because what do we mean when it says unless specified otherwise? And some people have said, hey, you know, it's common language to say share and share alike to mean common tenancy and common. So we see a lot of wills where I give it to my 4 kids, share and share alike. Does that mean joint tenancy? Does that mean tenancy in common? And some judges have said share and share alike is such a common phrase that's been used to mean tenancy in common for so long that we presume that that's what they meant, and that's clear enough for us. And we have other judges who say the statute's real clear. It says it has to be a very clear statement that it's intended to be other than joint tenancy. So if you're going to do this and you want to avoid this, if you really do want it to pass, if the person really wants it to pass as tenants in common, that's the language you want to use. I'm giving it to my 4 kids as tenants in common, period. Don't use share and share alike. I give it to my kids and to their heirs. Well, that sort of implies, because joint tenancy doesn't mean it's going to the heirs, it's going to the other joint tenants, right? So that's sort of inconsistent with joint tenancy, and we've had judges who said, if they say that, I'm giving it to my kids and to their heirs, or the heirs of my body. How many people have heard that term? We've heard it back in the old days when I went to law school so many years ago, back in when they had stone tablets. But it's a term that turns up in Oklahoma a lot. I don't know why in Oklahoma, but that's where we get it. Get wills out of Oklahoma that use that phrase for some reason. Otherwise, it's presumed to be joint tenancy. Why? Well, this is another effort to cut down on fractionation. Because what happens if you give it to 5 people as joint tenants, the last one standing gets the whole interest, right? It all ends up in the last one standing. And so it didn't fractionate. It only fractionated sort of in the middle until you got there. And the only way they can all sell it is they all have to sign off on it. So the presumption of joint tenants, unless the language is clear and expressed to pass it otherwise. Now, this does not apply to any will made before June 20th, 2006. Why? That's when APRA became effective, essentially. So, a will that was made before that, we don't apply this presumption. But if the will was made after June 20th, 2006, this presumption applies. Another little trick to catch you when you're drafting these things. Now, I don't, pretermitted heirs, what happened? Oh, okay. What happens with pretermitted heirs and adoptions? Well, adoptions is easy. They inherit in the adopted family only under APRA, not in the natural biological family. Once the adoption is done, they are now a child of the adopting parents. And and inheritance goes both ways, either from the child to the adopted parent if the child predeceases and then that's who's the next in line, or from the adoptive parent to the adopted child. That's the usual direction. That's the rule under APRA.
It doesn't matter if the child's a non-Indian or an Indian?
Well, they have to be an eligible heir, so it goes back to the eligible heir. All right? So even if they're an adopted in and they're non-Indian adopted in, they're not going to inherit because they're not an eligible heir. They may be an heir, but not for purposes of inheriting trust property. They're not eligible. So you have to remember that. A lot of the little nuances that you got to keep in mind when you're dealing with these things, because there's a lot of these little special rules that apply. What about the pretermitted heir? The child that's born after the will, not named in the will. Okay. They're going to take an intestate share, just like in the normal case of pretermitted heirs. They'll take an intestate share. Same thing with a spouse. Got married after made the will, then died. What does the spouse get? They get their intestate share, unless there have been other provisions made for them. They get their intestate share, but remember what the spouse gets. Their intestate share is a life estate. So that's all they're going to get. Adoption, that's within the family, we talked about that. All right, now let's see. Oh, there is one exception to the adoption rule. Always one exception, only under APRA. If the child maintained a relationship with someone other than their natural parent, like their natural grandparents, for example, or an aunt or an uncle, they may inherit from that person, but not the parent that adopted them away. So it often happens, the parent says, I can't handle these kids, I'm going to let them be adopted. But the grandparents maintain that relationship. They can still inherit from the grandparents, just not their natural parent, even after the adoption. That's a special rule in Indian country. It happens fairly frequently. I was raised by my grandparents. I wasn't adopted, but I was raised by my grandparents, and that happens fairly commonly. All right, covered that. One other thing we get into, and this one is one that drives everybody crazy. Oh yeah. I don't have my Tammy Wynette song, but you can imagine D-I-V-O-R-C. What happens in a divorce? Well, under the old rule before APRA came along, a divorce made no difference. The Board of Indian Appeals said, we do not recognize changed circumstances. If they made a will, they gave everything to their first spouse, and they got married 3 other times and divorced in between and never changed the will, the first spouse still gets it, if the will is approved. That came up out of an Oklahoma case. The person made a will, got divorced, got remarried, had more kids, got divorced, got remarried, had more kids, got divorced, died. And the kids came in and said, we want our share. And the first wife came in and said, I have a will. He gave it all to me. And the judge said, well, that doesn't sound very fair. All of this happened. Changed circumstances. We're not going to recognize that will. Board of Indian Appeals said, no, we don't recognize changed circumstances. This was an old law case. We don't recognize changed circumstances. First wife gets it all. APRA took care of that. APRA said once you have a divorce, that spouse gets nothing if they're in the will. They're out. Divorce ends that. If the will was made after June 20th, 2006, and if the marriage occurred after the will was made. The spouse then gets the intestate share. All right. Class devises. Yes?
One more clarification.
Sure.
Just to make sure, okay. So anyone married before the 2006, which there's probably plenty out there, got divorced before the 2006 rule, no,
The old rule applies.
huh?
The old law applies. Unless they change their will, the will controls.
The will would survive. That's what I thought I understood.
Yep.
That's kind of scary.
That's correct.
Just saying.
So any of those people who made a will and got divorced need to be thinking about that.
Yes.
Especially if they
Scary
made
for
the will
them.
before June 20th, 2006.
What if, okay, same partial question, what if they remarried, didn't do a will, and I think I still understand the answer, but I want to verify, didn't redo a will and still have that old will hanging out there, that first wife gets it all?
Yep. Now, there is, the exception to that is this. There's always an exception,
I
right?
like exceptions.
Yeah. The exception to that is the person made a will in 2000.
Okay,
They left it all to whoever.
number one, yeah.
They got divorced, they married again, but they got married after 2006.
Okay,
Now, APRA applies on the second marriage, so that spouse is still going to take their intestate share
okay.
in that second one. And it gets really fuzzy, and you really need to look at 2206J2A1. J2A1. 2206J2A1. Because it lists a bunch of exceptions.
Okay.
And I don't even try to explain it because it's so complicated.
Okay.
It's really convoluted, so you really have to just track it down
But
in
the
the
first-
individual case.
A partial thing, the first wife still may get something.
Still may get something.
Oh.
So you gotta be careful.
Okay,
All right.
got it.
Question.
Yes.
Pending divorce, can a person write a will restricting what a spouse might inherit to whatever those minimum levels might be, whether it's intestate or some other statutory provision, in the event that he dies before the divorce is finalized?
Yes. Now, presumably we're now after June 20th, 2006. They can write a new will. In the case of a divorce, they can change their will. And if they're in the process of divorce, that they don't have a divorce yet. Good idea if you're dealing with the divorce is to try to get a property settlement, because we will recognize a property settlement as resolving those issues. If they haven't got that, it really becomes iffy, because it's depending on the law of, like California, I think has, you file for a divorce, you get a decree, but it's a temporary decree, and there's a period of time before it becomes a final decree, and so on. Some states, it's not that way. You get a final decree, it's done. Some states, it's not so easy. So it's really important. Now, the way around that is you try to do a settlement agreement and deal with this stuff. And if you only have to deal with the Indian property, you try to get that resolved, because we will follow the settlement agreement if there is one, even if one of the spouses dies before the divorce is final. If there is a signed settlement agreement, we'll follow it. Okay? Class devises. Again, this is the heirs of my body, right? I give it all to the heirs of my body. Well, who are the heirs of your body, right? And how long do we have to wait before we know who the heirs of your body are? Well, if you had 3 children, do we have to wait until those 3 children die? And if any of them had children, do we have to wait until they die before we know who the class? How do we close the class? Because the heirs of my body could be an indefinite number and could go on forever. As long as each generation keeps having more kids, you have more heirs of your body. The rule here is in 2206H2B. 2206H2B. And it says we will close the class whenever any member of the class is entitled to enjoyment of the property. At that point, we close the class, distribute the property, end of discussion. We're not going to wait for any more kids. Only those kids who are living and in existence at the time that class closes, when somebody's entitled to take the property, that's the end. If there's only one kid at that point, or one grandchild left standing, that's it. We close the class. As long as there's at least one person. There could be 10, or it could be 20. As long as there's at least one, we will close the class by statute when there is one person entitled to take under that provision. Because we pulled our hair out trying to figure out how long we have to wait before we can determine who the heirs of my body are. And somebody said, you could have to wait forever. Well, what about the rule against perpetuities? Everybody remember that one? If you don't, watch Body Heat. The only movie I ever knew about that deals with the rule against perpetuities. All right. Consolidation agreements, 2206J9. people can consolidate their interests. This is one of the provisions that Congress built in so that people could try to stop the fractionation and put it back together. So if you've got 4 kids and they own, and they're all going to inherit, they can enter into a consolidation agreement. Let's, just for simplicity, say there are 4 tracts of land in the inventory. They can agree amongst themselves that one will take one tract, one will take another tract, one will take another tract, and one will take another tract. So none of the tracts get fractionated and they all get a piece of the estate. That's one way to do it. It's even better than that, because they can bring in outside interests that they already own, that are not part of this estate. They can bring them in and trade them amongst themselves in a settlement agreement or in a consolidation agreement. So one of them has interest in this tract, and one of them has interest in this tract, and that tract, and that tract, and then they're going to inherit 4 different interests. They can bring in all of those other interests that they own already, add them to the ones they're going to inherit in this estate, and consolidate them and divvy them up that way. You can do that with a consolidation agreement. And the nice thing about it is you don't need an appraisal. You might want one, but they're not required. Unlike gift deeds or sales, you don't have to get an appraisal. You just bring in all the things, mix them all up, divvy them up, and say, this one's going to take these interests, this one's going to take these interests, this one will take these, and this one will take that. And when that's all done, it all gets included in the agreement. It gets included in the final order that comes from probate. Done deal. So it's a useful tool if you're dealing with a probate case and you've got parties who want to consolidate their interests. They may have a whole bunch of little tiny fractions. They want to trade them among themselves and get bigger fractions, because they're probably never going to get a hold yet, but they at least can make their fractions bigger. They might have fewer of them, but they'll be bigger. Okay. So it's a useful tool to keep in mind if you're dealing with these things. All right, what's next? Why are you here? That's an open question. You have to answer that for yourselves. I don't have an answer to that one. It's the question I asked, though. I'm here because of them, to help people try to figure out what happens to their property and how to make it work smoothly. How do we get it from here to here, or from here to here in some cases? And how do we make it work? That's why I do this. That's why I've done it for 13 years. Any questions? It's right at 1:30. Yes?
I don't think, did you cover sale at probate? Are we still trying to do those?
Did I have what?
Sale at probate, did you cover that?
Oh,
Did you do that?
no, I didn't. But I could. You want me to talk about purchase and probate? Purchase and probate is the nightmare of our world. But there are provisions where if land is going to the tribe, for example, if the tribe is the heir, then APRA allows for any of the co-owners to come in and purchase that interest, rather than have it go to the tribe. So if you have someone who is a co-owner in this interest, they already own a share that they got some other way, they can purchase before the tribe gets it. And that's where it gets complicated, because we then have to get an appraisal, number one. We have to notify all the other co-owners, because they also have the right to purchase. And then if they want to purchase, then we have to have a sale. Now, the regulations are not clear on how that works. And the way I normally do it is I will do this. Get the appraisal, I will send out an order to show cause. And I'll say, here's what the property is valued at. Here are the eligible purchasers, that is, co-owners who have an interest and are interested. And if you want to buy it, this is what that interest is worth based upon this appraisal. that you can look at. We don't normally send out the appraisals because they come in and they're about this thick. So we say, you can go down to the BIA at the agency and look at the appraisal if you want to, or you can go to the regional office and look at it there, or you can come to our office, wherever that might be, and look at it there, and you can decide if you want to purchase it. If you do want to purchase it, we have to have a bid within 30 days, 60 days, whatever, how much time we give them. And they then will either submit a bid and say, yes, I want to purchase, and this is how much I'll bid on it. And then we'll look at all of those bids, and we take the highest bidder, and we notify them, you won, pay up. And under the regulations, you have 30 days to pay up. And if you don't pay up, we don't go to the next bidder. That's it, no sale. Now, because these things are so complicated, I usually do two things before that. I will send out an order, and not all the judges do this. When I do them, I do this. I'll send out an order that says, first of all, the BIA has given us an estimate of value. This is the estimated value. We haven't gotten an appraisal yet, but this is the estimated value. Are you interested in buying? If you're interested in buying, it's going to cost you this much, and you're going to get your 1/54 share for this much. If you're interested, you need to let me know. If you're not interested, if I don't hear from you, I'm going to assume you're not interested in buying it. If you're the heir who was going to inherit and it's going to get bought from you, I don't presume the other way around. I say this is what, if you have to consent, and there are some special rules. If the tribe is buying it, if the secretary is buying it on behalf of the tribe, and it's less than 5%, and it's not an heir who's living on the property, if those conditions are met, then it's a forced sale. They don't have to consent. Pretty much anything else, the person who would be the heir has to consent to the sale. So if they have to consent, I will ask them, first of all, do you consent to a sale? And sometimes you get back, no, not no way, not no how. I am not selling this property. It was my grandmother's property and it's staying. I'm not going to sell it. If that's the case, then I'm not going to go get an appraisal. If they say absolutely no, I will not sell it no matter what the price is, then I'm not going to get an appraisal. I'm not going to jump through that hoop because that's a $4,000 or $5,000 expenditure for this less than 5% property. Not going to do it. If they say, well, it depends, which is we get from time, depends on how much you're going to pay me for it. I might sell it if it's worth it. So then we have to jump through all the hoops. We get the appraisal, we send out the appraisal, or we tell them what the value was, the appraised value, and tell them they can look at the appraisal if they want to. And then we ask them again, at this price, are you interested in selling? If so, you need to tell me, yes, I will consent to a sale at that price. I do not presume that there is consent. Because I don't know if I send out a notice if they didn't get it, that they might not have consented had they got it, or they might have said no, at that price I don't. So I don't presume that they consent by non-response. I require a positive response. Yes, I will sell at that price. Sometimes they say no. Sometimes they say yes. In which case, we go ahead to the next step. And ultimately, we will have a sale. And we get a bidder and they say, that's what we're going to pay. We send them an order, say, you won, pay, and we tell them where to pay and how to pay. They have to pay to the lockbox, the BIA lockbox. And it has to be sent by this date, and if it isn't sent by this date, the sale's off, and it passes to the heir. So that's purchase at probate in a nutshell. It gets done. We have a few more of them happening all the time, but it is a cumbersome process. It's one of those things where Congress didn't think through what they were doing, because they created a process that is very complicated, very time-consuming, and very expensive to deal with little teeny tiny fractions of land. Because I mean, you can have a purchase of over 5% lands. It can be done, but it always is gonna require consent at the 5% or more. The only time it will not require consent is the less than 5% and the tribe or the secretary is purchasing on behalf of the tribe. Then it doesn't require consent. Otherwise, it's gonna require consent. And we wanna try to avoid expending a lot of money on something that may or may not ever happen, and even if it does happen, it's for $1.98. And we've just spent, several $1,000s getting an appraisal, not to mention the time of the judge and the staff and everybody else mailing and all that stuff that goes out along with it. It's an expensive process. Ill-considered in my opinion, but then I have that same opinion about a lot of things Congress does. Okay? Any other questions? This is my information. If you need to get a hold of me or want to get a hold of me, if you have any other questions, you can call the office in Albuquerque, send a letter, send a fax. The fax number is 5341 instead of 5330. And we try to answer them. We don't, I won't answer any questions about specific cases. Can't do that. But somebody on staff will try to give you an answer if you have questions. Okay? Anything else? Thank you.